This online presentation has to do with the relationship between justice and rights. In the previous presentation, we have shown that there's a close relationship between the idea of justice and our commitment to human equality. In this presentation, we want to look at the relationship between justice and the language of rights. There's a very close relationship between the two. Indeed, we often talk about justice using the language of rights or making claims that people have certain rights. To say that someone has a right to something is to say that that person has a legitimate expectation or a justified claim with respect to their treatment by others. To have a right means that one can justifiably expect and demand the types of treatment appropriate to the right. Another way to say this is to say that rights generate or point to obligations or a set of obligations that someone else has because you have the right. Thus, it is often said that a person's rights are rights held against someone else. That is to say, they point to someone else's obligations and duties in relation to you. Those obligations that others have in relation to you because you have a right, or that I have in relation to you because you have a right, may be either negative or positive, just as we've seen in relation or in comparing the principle of non-maleficence with the principle of beneficence. A negative right is one that generates negative duties. That is to say, a negative right requires me not to do something, whereas a positive right requires me to actually do something on behalf of the one who holds the right. Having a right does not mean that it is morally right or justified for you to exercise that right in any particular way. Remember, if you have a right, that means other folks have an obligation. If we are deciding what someone should do, the rights of others are relevant, but their own rights are irrelevant. Let's make this personal. I have a right to free speech, so do you. That does not mean that anything you or I might say is morally justified or right. What it means is other people may not interfere with us, even if we should choose to say something that was wrong, like something that was scandalous about another person that wasn't true. So if I were to say something truly evil or to speak an obvious lie and you said to me that was wrong, it would be meaningless for me to say, no, it wasn't. I have a right to free speech. So let me summarize briefly what I've been saying. Having a right does not mean one is obligated or even permitted to exercise that right in any particular way. If we are deciding what someone should do, it's only the rights of others that are relevant and the principles that are applicable to that person's action. And an appeal to your rights does nothing to justify your action. An appeal to your rights only says what others may or may not do. At the beginning of this presentation, I suggested a close relationship between rights and the principle of justice. We often speak of justice using the language of rights. Given that the principle of justice has primarily to do with institutions, particularly institutions like the government, and the legal structures it puts in place and enforces, we typically invoke rights when we are trying to say something about the responsibilities of government. You might recall Jefferson's claim in the Declaration of Independence that the very purpose of government is to protect people's rights. So, for example, when those who talk about a right to life are typically pointing to the government's responsibility to pass laws that protect those from being killed who have a right to life. The right to life movement is working to get the government to declare abortion as illegal, overturning the Roe v. Wade decision, for example. It's also important to recognize that when we invoke the language of rights, we are intending to protect ourselves from government. Given their power, Governments themselves may represent the greatest potential threat to us and to our rights. As a result, we use the language of rights to point to claims we make against governments. When we talk about rights, we are typically pointing to obligations that governments have first for guiding their own conduct in relation to us, and only secondly, to put in place measures that assure that individuals and other non-governmental institutions meet their obligations to us related to the rights in question. Probably the most significant reason for the idea that there's a close connection between the language of rights and the principle of justice has to do with the fact that when we talk of rights, we're often talking of what are called universal or human rights. Consider this definition of rights from the Oxford Companion to Philosophy. They say that rights are justified claims to the protection of persons' important interests owed to persons for their own sakes and essential to human dignity. We often refer to things as rights, which we think people have simply because they are human beings. And those rights protect aspects of what it means to be human that are essential to our dignity. Now, not all rights are human rights. Not all rights are universal rights. We have some rights not because we are human beings, but because of particular agreements or relationships that we have with others. For example, if you sign a contract, you generate rights and responsibilities for all the parties involved. Spouses may be said to have particular rights in relation to each other, and children rights against their parents. Even the rights that all citizens have in a particular society because of an implicit social contract thought to bind all together in a shared national community, or rights that one may be thought to have because of the unique contributions or sacrifices you have made for that society. Those are different still, even from what are called universal or natural rights, rights that one or human rights, rights that one has simply because one is a human being. Consider these four characteristics that philosopher Richard Wasserstrom has identified as distinguishing general or human rights from specific rights. First, he says, a universal right must be possessed by all human beings as well as only by human beings. Second, because it's the same right that all human beings possess, it must be possessed equally by all human beings. Third, because human rights are possessed by all human beings, we can rule out as possible candidates any of those rights which one might have in virtue of occupying any particular status or relationship, such as that of a parent, president, or promisee. And fourth, if there are any human rights, they have the additional characteristic of being assertable in a manner of speaking against the world. Rights of the sort that Wasserstrom has in mind are often thought of as natural rights. By that I mean they are rights that are thought to be derived from certain essential facts about the way things are, or especially about the way we are as human beings. Natural rights, then, are thought to be derived from the essential characteristics of human nature that philosophers have identified. This way of thinking about rights is consistent with the reasoning we have discussed behind the principles of non-maleficence, beneficence, and autonomy. In our next presentation, we will look at those rights, those natural rights, those human rights that could be derived from those ways in which we have said already that all human beings are equal. That is to say, our shared physical, autonomous, and social nature. That in our next presentation.